Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Family Law, and I'm here with attorney Robert Howell to talk about military divorces. Today, we're going to focus in on how military benefits are treated in a divorce. So before we start in, though, Robert, can you tell us a little bit about yourself?
Sure. I grew up a Air Force brat, so my early life was all about living on base and moving from Maine to California. And later on, I entered the entertainment industry and was a designer for years. And then I adopted my youngest child from the Department of Children and Family Service. And he was my inspiration to go to law school. And so after getting out of law school, I focused on the issues that were important to me, which included dependency, adoptions, and things like that, and military issues, since that's how I grew up.
Well, that's perfect for today because we're gonna try to hit military divorces and all of the intricacies that are involved in that. And so we're going to focus mainly on military benefits. And Robert and I, afterwards, maybe in a month or two, we're going to have another one on support, parenting time, child custody, those kinds of things. But today we're going to try to focus more on military benefits. And so let's start with just a basic question. What determines if a divorce is a military divorce?
One of the parties has to be an active member of the military, and or the other party or one of the parties is retired from the military. And when the divorce happens, they're looking to divide the pension that active duty member had received or still receives.
That makes sense. So before we get into sort of the substantive of military benefits, aren't there differences in some of just the procedural stuff that goes on with military divorces? For instance, are the grounds for a military divorce different than they are in the state of Washington?
No, it's still irreconcilable differences. So the
same old way to get divorced.
Yeah.
What about residency or filing requirements?
That's one of the ways that Washington is kind of unique, is that it does not require any particular term of residency, just that you live here, and that the parties are in the state when the action is filed. Particularly with military, a lot of times the military service members hold residency in the state that they were born in. My own father was born in Ohio, and throughout his military career, he maintained his residency in Ohio. But even with that, if they're stationed here or here for some other reason, the court can obtain jurisdiction over them.
Well, yeah, because like I said, they're moving around and they're going to be somewhere. Mm. So how about, serving an active duty member of the military? Is that different from just a civilian divorce?
Yes. And depending upon the base, it can be more or less complicated. More often than not, if you need to serve somebody and they work on the base, then you need to arrange with the base commander, either directly through their office or through the JAG or the legal assistance office on the base, to have the party served, which can either be, normally what we do is we set up the person that's going to be served will go to the base and their name will be on the list at the gate there where they get to go in, and they will go to the base commanders of the JAG office, and then the party is called in and then they can be served right there. And the military is usually very cooperative, but it can be a little bit daunting for people who've never had to deal with going on a military installation. Now, the only exception to that is if the active duty service member is deployed. If the person is deployed, you cannot start a proceeding for divorce as long as they're deployed.
You can't serve them at all.
You can't serve them at all because their destination and where they are supposed to be secret. And so the Soldier and Sailors Relief Act specifically says that a member of the military, any service, cannot be served with the divorce papers while they're deployed.
What about getting a default or requirements for a military member to respond? Are there differences there in a military divorce?
Not really. They can still, the parties can always choose to come to some sort of settlement, in which case the military member does not need to respond. But if they are served, they should respond, so that the problem with being in the military always is whatever legal protocols are in place, you want to make sure you follow them, because it can have repercussions with your command. And if the other spouse decides to call his commander and let him know that this proceeding is going on and he's not cooperating, then they get called on the carpet.
Got it.
And so there's a little more pressure on them to comply with any kind of legal situation so that it doesn't come back and affect their military performance.
It kind of answers what my next question, kind of the why. Why are these different? Why are our military members treated differently in these procedures? And like you said, a lot of it's got to do with it's the rules of deployment kind of stuff.
Yeah, and they're just under a lot more scrutiny than your average citizen. And so you need to, as an attorney, I'm always cognizant of that fact and try to work with the military in any way that I can, so that we don't in any way impede this person's career.
Well, that makes complete sense. Talk a little bit about dividing assets. And while they're not quite the same, we sort of lumped dividing assets and dividing or transferring benefits. They kind of fall into that same sort of thing, but just a 10,000 foot view of dividing assets in general. Does that differ if they're in the military than in Washington, where we're a community property state?
Not really. It's going to be the state laws that control, and in Washington, since we are community property, then that's what's going to guide the court. But the court still has the authority and the jurisdiction to divide all assets, and that includes their military benefits and or pension.
And that's sort of where the uniqueness comes in, because dividing military benefits has rules that are federal as opposed to state, I think, involved as well, don't they?
Yes. And that's where the real kick comes in for an attorney, is making sure that you are aware of the federal rules that control, and also make sure that your judge is aware of them, so that an order that is made with regards to any kind of benefit is formatted in the way that the military wants, and they're very particular. So you have to be very careful with any order that comes out of the court.
Are there any restrictions or other sort of things that you need to also be aware of in terms of military divorces? I know that there's on a lot of their benefits that there's you have to be married for a certain period of time. They have to be in the military. Sometimes it has to overlap. How does that work on a pension?
Well, a lot of information out there, people go by what they call the 10-10 rule, which is that you have to have been married for 10 years and the person has to be in the military for 10 years before you can obtain any of their benefits for retirement. That's not really true. Particularly in Congress in 2017, through the National Defense Authorization Act, revised the law from what used to be known as a time rule, and now we use what's called the frozen benefit rule. Frozen benefit rule simply means at the time of the divorce, the retirement benefit to the other spouse is going to be based on the service member's time in the military and their rank. And it's supposed to freeze at the time of the divorce. But one of the catches to all of that is that if the divorce is not completed and signed off in the order then made an order of the court, then you can have all sorts of situations that are not going to be fun. Say the divorce, they make the agreement, but then they don't get divorced for 5 years. And at the time the divorce, the military member is now where he was a major before is now a colonel, and has got 5 more years of service. So now the previous order is not correct because it doesn't give his correct frozen benefit point, which is when the divorce actually happens. So it's very important that once the order is written that the divorce is finalized, so that the Defense Department, the pay section, gets an order that's correct at that time, and you don't have to go back and modify it because things didn't get finalized.
So I know in some regular civilian, what do you want to call it, pension plans or retirement benefits, there is a kind of a two-step process where the judge says, okay, you're going to get X amount. And then Y is it goes to the person who's running the retirement account, what they call sometimes the plan administrator, and the plan administrator has to actually agree to that for them to pay. And is that sort of the same way it's working in the military, where it's a matter of, to get the military to pay, you have to go through all these extra hoops?
That is the biggest question mark anytime you're trying to attach a retirement pension and get it paid out to the other party, is the military, which is not surprising. They're very strict about their format. And if the documents you send them aren't formatted in a particular way, they'll simply reject it and send it back to you for further modification, which means you might have to go back to court. And this can go on more than once. So it's very important that a lot of times it helps to contact the Defense Pay Department and get information from their legal services exactly how the wording should be, so that you don't get these rejections and having to go back to court to modify your judgments based on what the military is telling you they'll accept. So it can be a vicious circle for you if you're not really prepared.
It is, when we say the military, is it a Washington, D.C., office that handles every aspect of each military, or are you looking at, well, maybe it'll be different from an Air Force pension or Navy pension?
No, it's the Defense Department of Pay.
Got it.
So that's who you contact and that's who you work with. So it doesn't matter what branch of the military you're dealing with, you're going to be dealing with the same government entity to get the division.
Is there any limit on how much they'll pay? I suppose you could, if a judge could say, just depending on the assets of the divorce or the needs of each of the people, you're going to get 90% of this person's IRA. Are there limits in the military to stuff like that?
Yeah, the non-military party cannot get more than 50%, but there are other ways the court can offset a division that they feel it'd be more equitable. And that could be through spousal support. What also happens a lot is retirement benefits get modified because the military member qualifies for a disability, and the disability reduces their retirement pay. And then suddenly the former spouse is getting less money because less money is being paid out from the pension fund. And you then might have to go back. And this is where the real gray area is coming in for the court of how they can fill that gap. If there is a spousal support order, that might be one way that they can do it.
Can you just ask a judge, let's say a Washington judge, to say, well, we understand the military is only going to give X%, but I'm going to order you to pay part of what you receive to your spouse? How do we prevent that?
I believe right now there are a couple of cases that have gone through the appellate court, and it's really undecided law as to what authority a civil judge can exercise over the division of the military pay. And a lot of the case law that I'm reading on it is just all over the board as to what they're allowing. And so I think at some point, either our state legislature or the military is going to have to clarify these kinds of questions, because there's not the law there for them yet. There's decisions, but not law.
It sounds like that having an attorney who understands the military part of it is not just essential for getting the benefit payment out, but then determining the whole rest of the divorce settlement, because that's going to be potentially, I imagine, a significant part of it.
Right. And then there's another spin on all of this, which happens to be a case that I just picked up, is the party is already retired. The military party is retired, but the spouse is and was with him for his entire military career. So she is entitled to part of that pension. But now you're dealing with a pension that's already being paid out to the other party. And so you need a different set of orders because you have a pension that's in place. The only thing that really helps is we already know the amount.
Right.
And therefore, it's fairly easy for the judge to order 50%. And there's some debate too as to whether the order should be a dollar amount or a percentage. I myself prefer a percentage, because if the payout to the military person is going to increase over time because they get a cost of living adjustment every year. And therefore, rather than lock your client into an amount that they get that's going to be forever, you give them a percentage, so they always will get that 50% no matter what happens to the pay of the military person.
And so 20 years later, 10 years later, when it starts to pay out after a divorce, you don't have to go back if you do a percentage then to determine what that dollar amount would be. They would figure that out.
Correct.
That seems like
as the defense department gets that kind of order, they're always going to know that they have to update the payments to the other party based on the court order, which is 50% as opposed to some dollar amount. And as a lawyer, I think that's more of an obligation on our part to ensure our clients' rights are protected over the long term. So we don't wind up going back to court.
No, that makes sense. I mean, it's, kind of that issue where you're trying to find a future value and you come into a number, but the number doesn't necessarily going to be right,
Right. And I know my own brother who retired from the Air Force as a major, I think he started at, and this was 20 years ago, probably 17,000 a year. And now I think it's $31,000 a year
Right.
is his retirement pay. So that's a significant difference. And you want to make sure if you represent the former spouse that you're protecting their rights, knowing that that's going to be the long-term case.
So what happens if you divorce a private or a corporal and years go by and at retirement time and they're now a colonel? Can you go in and change, or do you have to deal with that at the beginning, or how does that work?
Again, it depends on the time of divorce. With the new rule, it's time served plus rank. And again, I can go back to my brother. My brother was a non-commissioned officer for the first 10 years and then went to OCS and became an officer and retired from the military as a major. So he greatly increased his ability on his pension because of the fact that he went from a non-commissioned to a commissioned officer. And so again, to protect the rights of a former spouse, you want to make sure that at the time of divorce, that information is correct when it goes to the Department of Defense.
Wow. So this sort of barrier of 50%, what if you're not the first person to divorce that person? Is that 50% switched? Is it just an overall limit so that, if someone already has 50%, you can get nothing? How does that work?
That's an interesting question, but it's going to depend upon how long the marriage was, because that also factors into how much of the retirement you're entitled to. If you're there for the entire time, you're going to get that 50%. If you're there in a marriage for only 5 years, although the state of Washington still allows the division of retirement pay, they're going to base it on that fact that you were only present for 5 years of this person's service. So you may get 10% of the retirement pay, but no matter what, it should never, the federal law really prohibits any taking over 50%. So even if there are multiple parties, the court is going to have to be cognizant of the fact that they still can't take more than 50% of the pay.
If the spouse gets who is awarded a part of this pay gets remarried, are there issues there? Is it like spousal support or alimony where it could potentially go away? That's a very common question. And the answer is no, it never goes away. It is a right to the party that receives it, and their marital status, income changes, anything does not affect their right to continue to receive that amount for their entire life. Got it.
So
I believe that there are different things involved in military pay as well as military retirement benefits that could go on. As you mentioned, kind of disability do they all get put together and you get that X amount 50% of? For instance, you said there's a disability potentially, so you're paying some disability. Maybe that reduces some of, I guess, what you would call your normal retirement. I don't know if there's other kinds of retirement that can go in. How is that all treated?
Let's say a veteran gets, the VA determines that he's 30% disabled. And that 30% will come out of their 50% of their retirement. And that's where, or out of their retirement total. And that's where the other party is going to get affected. But the benefit, the amount of the benefit or retirement doesn't change for the service member. But the amount that's coming out of the pension versus the disability is going to change. And again, that's going to affect the rights of the former spouse. And so you might have to go back in for a modification to deal with that issue. The one thing, if you ever see a pay stub from the military, it's very unique. Because there are all sorts of allowances they get. The most common and the biggest one is usually a base housing allowance. If the party's not going to live on base, depending upon where they're stationed, the average I've seen is between $1,800 and $1,900 a month is added to their paycheck. And but that doesn't accrue to their military pay / pension. So there are elements that are on their paycheck for which they're getting paid. There's also overseas duty pay, combat pay. All of those will factor into their retirement. So there's a lot of complexity in looking at how a military person is paid and what part of that pay is going to accrue to their retirement. Again, if they got deployed, they got injured and they're on a disability, they could also get 100% disability, which is a problem I'm just now coming to realize, because that terminates their retirement pay. And because they're on disability, and if the disability is 100%, then you've got, and that's usually not touchable in terms of awarding to a former spouse. That's going to be problematic. And frankly, I haven't seen a case yet where that's addressed, so I'm not quite sure how the court's going to deal with it.
Yeah. Is, generally, I think the rule is that if you make a property settlement, I get the house and you get the bank account, you can't come in later and modify that. You don't really get two swings at that. But I'm wondering if military benefits like this have a little bit of a different view by the court because of just kind of what they are. And like you mentioned, what if the military member becomes disabled after the divorce, the pension, which was, already decided, goes away, or is reduced. Is there a way to modify either in the Washington courts or with the military, any sort of way to compensate for that?
It's going to depend upon the form of the judgment, as to normally when an order is made for the division of a pension, you still have an action that you can come back on. And so if it's modified because of disability, you're able to go back to court and get it modified, or the court can choose to compensate the difference through spousal support, but then there has to be a spousal support order in place, because normally once the judgment's entered, unless the court retains jurisdiction over spousal support, that's not going to be an issue you can go back to court for. So it might be incumbent upon any attorney writing a judgment where this is a possibility, is to make sure the court retains jurisdiction over spousal support, so that if a modification is needed, you go back to court on that issue. And that gives the court the authority to modify it and compensate the other party for it.
There's a lot of things that you as an attorney need to know, unique to really, especially when you're talking about the military pension, that drive just like that. Who'd have thought? I wouldn't have thought that you may just want to have even a de minimis spousal support. Especially if there's an issue that, a person has been hurt and maybe it'll get worse. I mean, that whole kind of thing, it's all part in finding an attorney who knows how the military works in this stuff.
Yeah, and that's what I think. I know some attorneys advertise that they do military divorces and things like that. And in California, that was part of my advertisement, is that I handle military divorces. And it's because you're dealing with so many unknown factors that can come into play. And when you're writing a judgment to preserve your own legal elements that will prevent any kind of malpractice coming back on you, you need to be very sure that you've covered all the bases and try to anticipate what might be an issue in the future.
Wow.
I know the California courts, it's just a checkbox on the judgment form to retain jurisdiction over spousal support. But I haven't run into that issue on the Washington court yet, so I'm not sure.
Wow.
Well,
I know we're running up towards our 30 minutes, but just let's talk a little bit about, because that's not the only benefit, the pension that a military member, has, or the family has. I know they have, I think everyone gets TRICARE insurance, they get the, what they call the ID card. And so there's other benefits that flow with being a spouse. Do any of those kind of transfer to a divorced spouse, or can they?
Anytime you have the former spouse of a retired military person, then that former spouse, in some bases, view it differently, but more often than not, if the person put in 20 years, their former spouse is entitled to all the base privileges. They get to keep their ID card, which gets you onto the base. You can use the base commissary. You can use base medical facilities. One of the big reasons that a lot of ex-military retire in San Antonio, Texas, is because there are 5 military installations near San Antonio. And so they can avail themselves of all the privileges they had when they were in the military. And if you have children, the children can retain their IDs until they're 21. And so they can continue to enjoy the privileges of on-base commissary, PX, and all of that, which frankly is pretty significant because you don't pay any taxes for any of those. And so it can be a pretty significant advantage to have that. And certainly you want to make sure that in a long-term marriage that the former spouse is getting those privileges retained.
I'm sorry, do those privileges go away if the spouse gets remarried?
No.
So this is a big deal. I mean, in medical insurance is just by itself is a huge benefit.
Exactly. And so again, I mean, even up here with JBLM close to Tacoma, it's always going to be a big issue, if the party can keep access to that base. And particularly in these kind of crazy economic times, that's a huge benefit to your clients. So.
Oh, absolutely. Wow. That is really, really eye-opening. Lots of information. I really thank you. And we didn't even touch, child custody, child support, parenting time, what to do with parenting time if someone is deployed. I mean, all of those things. So we're going to have you on again.
Okay.
And I see just by this conversation that even those things sort of become interwoven with the other military benefits. And it's a puzzle. You need to have all the pieces. So, wow. Thank you, Robert, so much for being here today. It was really cool.
All right. Thank you. I enjoyed it.
I did too. And everyone, I just want to thank you for coming again, as always, to our Facebook Live. Anyone with any questions further from today's topic, please feel free to post it here. We can get you connected with Robert. So until next time, stay safe, stay happy, stay healthy, and we'll tune in next time. Goodbye.
Hey.